Hi, this is Rahul Reddy along with me is Emily Neumann. We are live here on every Tuesday at 5 Central Time. We're going to answer your questions with regards to the immigration. Emily?
Thanks for joining us today. My name is Emily Neumann with Reddy Neumann PC. We've been practicing employment-based immigration law since 1997 and are here every week to answer your questions. If we don't get to your question today, or if you'd like more information or want a more detailed response, you may want to join one of our free daily conference calls that we hold. You can find the schedule for that and the login information by going to rnlawgroup.com. And also, if you want to set up a consultation with any of our attorneys, you can visit rnlawgroup.com, click on appointments, and you'll be able to find all of our attorneys and the process for setting up that consultation. Today we're going to be talking about all the latest in employment-based immigration, specifically in H-1B trends that are going on, what's going to happen in the 2019 lottery. I can't believe we're already talking about 2019 when we haven't even finished 2018 yet. Updates on H-4 EAD, talk a little bit about day one CPT, duplicate filings, and answer your questions in between.
Emily, mostly the recent trend seems to be that the H-1B denials have been very many. So I want to take up more time with regards to why are the H-1B denials are coming? If there is an H-1B denial, what are the alternative options? There are some questions that are being faced by a lot of clients. If the H-1B extension is denied and the I-94 is expired, can they now join a university and apply for change of status, or do you think so there'll be a problem in there?
Yeah, there'll definitely be a problem there. So once your status has ended, which a denial of an extension where the I-94 is already expired, or the denial of a transfer in that situation, once you're out of status, you can't get back into status simply by filing a change of status to something else. So just by filing that I-539 to switch to F1 status, because you're out of status at the time of filing, it's not going to keep you in a period of authorized stay. And if your I-94 is expired, you're going to be accruing unlawful presence the entire time it's pending. Right now, those applications are taking a year to process, so you're going to be sitting around accruing a year of unlawful presence while you're waiting for it, and then when you finally get the denial and you leave the country to go apply for the visa at the consulate, you'll be barred for 10 years. So not a great plan. Unfortunately, once a denial happens, if your underlying or your previous stay has already expired, there aren't a lot of options for you to get back into status without leaving the U.S. So definitely contact an immigration attorney, go through all the options, but most likely you should be able to get back into status by exiting, either filing a new petition, applying for a new visa stamp, and then coming back in to regain your status.
Emily, one other thing is that nowadays we are noticing some of the H-1B approvals coming without the I-94 when they have actually filed for the change of status. They are not only, they are approving the H-1B, but they are denying the status. Can you comment more on this when it is applicable, when the STEM extension person's status has been denied but the H-1B is approved? What are the consequences? What are the actions they need to take? And I want to address CPTs separately.
Yeah, so when USCIS issues a decision on the status saying that you violated your F1 status and therefore were denying the change of status, due to the August 9th memo on unlawful presence, it's a lot different this year than it was last year. So in the past, when that happened, when you got the denial of the change of status, you would exit, apply for the visa stamp, and come back in H-1B status. Now, remember, the August 9th memo says that when a denial of a change of status occurs due to a status violation, they're going to count unlawful presence from the day the violation began, not from the day of the denial. Now, if the violation started before August 9th, then they will count the unlawful presence from August 9th. So if you're in the situation where your change of status from F1 to H1 has been denied due to a status violation, such as not complying with the STEM OPT or doing CPT after using up all of your OPT time, those are considered a violation of status, which means unlawful presence began August 9th. And you have to make sure that you're not exceeding 180 days of unlawful presence. Otherwise, you're going to be ineligible for the H-1B visa stamp for the next 3 years. So if you're in that situation where your change of status has been denied, you need to speak with an attorney right away so that you don't cross 180 days, which is going to be in February. So if it's happening right now, you probably have time to take preventative measures. But this is going to be a big issue for the many, many cases that are still pending right now that are going to be pending in February. They might get the denial after they've already crossed 180 days. Now, there is a lawsuit that was filed on that unlawful presence memo issue. So maybe we'll see an injunction or some sort of action taken by the court to force USCIS
Yeah, but I don't
to
want
not,
people to count
right,
on
we
that.
we can't rely on that for sure. So we need to take action based on what the law is today, which says that unlawful presence began August 9th.
We've also noticed that a lot of people who have applied for CPT to H-1B, their H-1Bs got approved and the change of status got denied. The same rules what Emily has prescribed for the change of status where the unlawful presence are applicable from CPT to H-1B. In the RFEs, when the CPT was being raised as a question, that whether or not the CPT is legal, we are speaking about day one CPTs. Almost every case, the status is getting denied. And in the issue when it is stem extension to stem extension to H-1B, it depends on how the documentation is, if the employer has supervised the employee, or if the employer did not supervise the employee, that employer did not control the employee, employer did not train, then only the stem extension to H-1B status is getting denied. But in the cases from CPT, when the status has been questioned, almost certainly every case, the CPT to H-1B change of status is getting denied. We did predict it from the beginning, me and Emily and REDDY NEUMANN PC, we've been telling that these day one CPTs are dangerous and not, may not be constituting to be legal, and that's what exactly USCIS is doing right now. They're denying all the change of status. Now, we have also noticed that when the H-1B is denied, they not only denied the H-1B, they went on further and they indicated that the person who is on the stem extension has violated the status. And when those people where the H-1B got denied, their status also when they are on the CPT, the USCIS went on further and they stated that their CPT, they did not maintain the legal status. In those cases when the H-1B is not approved, and the USCIS has indicated clearly in the denial that the person violated the stem extension, the person violated the status of the CPT. What is the situation in those things? What are the options that are there? Does the 180-day rule, the August 9th memo is applicable to them? What are the corrective actions that they can take?
Yeah, the unlawful presence memo from August 9th does apply to those situations as well. So you again have to be careful that you've not exceeded 180 days of unlawful presence before you take action. In this situation, if you are planning on continuing your studies in F1 status, you would have to get a new I-20, new SEVIS record, exit the country, apply for a new F1 visa stamp, and then come back in order to regain your F1 status. So definitely, again, speak with an immigration attorney before you take any action on that to understand how that kind of denial impacts your current status and your ability to get the new visa stamp in the future.
Emily, before we go into the question and answer, I want to go quick updates with regards to any updates on H4 EAD, any regulations?
No, I checked this morning, still nothing submitted to the OMB. As we heard, at least previously, the Department of Homeland Security is planning on proposing regulations by the end of this year. At this point, it looks like that might be the last week of December because they still have not submitted it to OMB. So if we see it submitted to OMB sometime in the month of November, then I think we can expect it by the end of December that we actually see a proposal. Again, the proposal doesn't change anything right now. That's just what they're planning on doing. We'll have the notice and comment period, so it'll be several more months before anything actually happens. But as of today, still nothing at the OMB.
Anything on the premium processing? As you know, that premium processing is suspended. It's only available for the extensions without amendment. and then they're going to reintroduce, I mean, it's suspended until February. Any updates on that?
Yeah, I haven't heard any rumors about them not opening it back up or continuing to expand the suspension. So hopefully that will come back in February as they originally planned. On that topic of premium processing, so we're seeing a lot of H-1B petitions that were pending at Vermont and California that have been transferred to Nebraska, where premium is available. Can those people now upgrade to premium processing?
No, they cannot upgrade to premium processing just because their case has been transferred to Nebraska Service Center. If it were to be filed in Nebraska Service Center where it's only an extension, then they could do the change of status. I got a lot of questions from YouTube, and you got a lot of questions, I guess, from Facebook. One question that came from Mr. Kumar is that, can I go for visa stamping for Ph.D.? Currently, I'm on a CPT pursuing second master's degree. Very high chances that if you go for visa stamping, you're going to get the denial because the administration does not like the CPTs. Not only that, that you continued working on CPT on second master's degree, I doubt this particular university that is giving a PhD admission to you. Some of these universities, I don't want to name them live here, some of these universities, they do not conduct any classes. They conduct once in a month. I don't know what kind of universities they are. But when we did publish an article that the CPTs that these people are doing may not be legal at all, we were being contacted by these universities, and they started asking questions to me and saying, hey, can you, why can't we do the remote? Don't you accept technology? I said, yeah, we do accept technology. I mean, we do. You can train the people, but why do they need to be in this country, an F1 visa, if you were to conduct the classes online? I mean, you could be in India, and then they could be conducting the classes. They don't have to be an F1 visa. The reason why F1 visa has been granted is for you to go to college here in USA. If you were to remotely and distantly study, I mean, you could do that in India. There's nothing wrong with it. But I do doubt some of these universities how they are giving. I do doubt whether Mr. Kumar is going to get the visa approval.
Satya has a very common question that we're seeing right now. His H-1B is expiring in January. The extension's been filed, still pending. It's very likely that it will still be pending in January when the current petition expires. What can you do in that situation? I think that with premium processing not available, that's going to be problematic. You've got to, obviously in your case, the extension's already filed, but when you're preparing your extension for filing, your employer or their attorney really should be looking at what is the current trend, how can I make sure that this is a strong case for approval so that you have better chances. We know there are certain things that cause RFEs. We know what they're looking for when they're denying petitions, so we need to do our best to avoid those from the beginning at the time that we're preparing the extension for filing. Now, other options you might have, if you're married to another H-1B holder, you could consider filing a change of status to H-4 before your current I-94 expires. That way, if the H-1B extension gets denied, you've already got the H-4 that was filed while you were still in H-1B status. Some people have been filing a transfer as a backup, which there's nothing inherently wrong in that, but it does create some issues on which company do you really intend to work for. And what we're seeing a lot of times is the transfer is being filed to work on the exact same project that you're already working on. Now, there's really only one job. How is it two companies can
are saying that their job belongs to which company?
Yeah, and which company has the right to control for employer-employee relationship and those sorts of things. So there's some things to just be really careful of there. But filing a change of status or possibly a transfer to another company where maybe the case is stronger might be an option.
Emily, I have a question for you from YouTube. Shivani has this question that, have you seen any notice to appear, NTA, when you are getting the denials? Can you explain more on how this NTA, have you seen any NTAs after they issued the memo?
No, I've not received one yet. So this is related to the NTA memo or the notice to appear memo that came out in June or July, was kind of backtracked put on hold for a little while, and now it's moving forward again. So the NTA memo only applies to I-539s and I-485s in the employment-based category. They recently expanded it to other types of applications, but nothing really related to employment-based as far as I'm aware. But they are continuing to implement this, so it's going to be moving on to I-129 at some point. But what the memo says is that if your application or petition has been denied, and at the time of denial your I-94 has expired, you are unlawfully present, you're out of status, nothing's changed there. But now, if you don't depart within 30 days, which is the time allotted for an appeal, they will issue an NTA. Now, we have seen denial notices on I-539s where they do talk about, they changed the language in the denial to clearly state that you have 30 days to depart or an NTA may be issued. That was never there before. Now, so far we haven't had any NTAs actually issued in our office. I'm not aware of any others out there specifically for I-539s or I-485s, but they are moving forward with that memo, so it's something to keep in the back of your mind.
Ramya has this question: how fast the Texas Service Center is taking for the I-140 adjudication, and what are the chances of percentage of approvals in the I-140 in Texas Service Center? It's taking about 5 to 6 months for the Texas Service Center, but you have a premium processing. If you want to avail that, you may want to use the premium processing to avail the I-140. We are not noticing much denials on the I-140 overall, but it depends on your case. I would say that the percentages chances of approval is way higher, especially when you compare to the H-1B. I-140s are fairly going through smoothly. Touch wood, we don't want to disturb it, but it's going very smoothly. The chances are very high. I don't know your case, but in general, nothing much has changed in the I-140.
All right. Raja has a question about travel while an H-1B transfer is in process. Generally don't recommend it. It's going to, when you go out and come back in, you're going to have an approval notice for one company and a receipt notice for another company. You come in on the approval for one company. Which company are you intending to work for is going to be a question, as well as you're going to get a new I-94 card when you enter, but your approval of your transfer is going to come with a different I-94 number, and it's going to create a mismatch there in government databases, creates a big problem. So I generally would not recommend that. It creates a question of your intent, which company are you actually intending to work for, as well as I-94 mismatch problems.
There are a lot of questions coming on the I-140 portability and also EAD. I want to make sure that things are clear. There are like 7-8 questions on that right now on the YouTube. One is that if your I-140 has been approved and it's been 180 days, the company has not withdrawn that I-140, the porting of the date is almost certain when you move to company B, unless there is any fraud involved in it. So it's a regulation. It's not something that I'm interpreting or the officer is interpreting. If the I-140 is approved for more than 180 days and it's not been withdrawn before January 17th of 2017, you are assured to get the porting of the date. Absolutely, I have never seen any problem, never seen any RFE when the I-140 was not being withdrawn within 180 days after the approval, and also if it is not withdrawn before January 17th. So if it has been withdrawn before January 17th of 2017, we have a problem. If it's withdrawn after January 17th of 2017 and it's more than 180 days by the time the approval is there, that priority date will belong to you. That I-140 will belong to you. You can use that for H-4 EAD extension. You can use that for porting the date. You can use that to move to company B when company A got the I-140 approval. You can move from company B to company C using the same I-140 that got approved with company A. Absolutely no problem. We have never encountered any problem. There's also a question that came out is that if the EAD has been approved with the company A's I-140. If you move to company B, is the EAD still valid? The answer to the question is yes, the H-4 EAD is still valid. You can still file H-4 EAD with company B. Even though you don't have an I-140 with company B, you can file an H-4 EAD with company B. We have never experienced any problem in that thing.
Vinay has a question on downgrading, which is a popular topic right now that EB3 priority dates are more favorable in the filing dates chart than EB2. When you downgrade from EB2 to EB3, can you also file your EAD at the same time? In a roundabout way, the answer is yes. If your priority date in EB3 is current using your EB2 priority date, you can file the EB3 I-140 to downgrade and your 485 at the same time. When you file the 485, you can include an application for the 485 based EAD. So yes, assuming your priority date is current at the time you're filing the downgrade and you're filing the 485 along with it, you can get an EAD.
And then to elaborate a little bit further on that, normally when we downgrade from EB2 to EB3, we can use the same labor certification in downgrading from EB2 to EB3. We don't have to necessarily file another labor certification to get the downgrading from EB2 to EB3. Now, if it's vice versa, EB3 to EB2, we may need to file another fresh labor. Most probably we need to do when we are upgrading. When we are downgrading, we may not need to file another labor certification. However, we do not recommend downgrading unless the EB3 is current for you and EB2 is not current for you. Only when you have that, I would recommend to spend that extra money. If that is not the case, where your priority date is not current in EB3, there is no need to downgrade at this point of time. I'll wait and see how the things will move. We're expecting the movement from EB3 to EB2 going up, back and forth, just like the way it happens for Chinese nationals. So we don't know which time it's going to be the other way around.
All right, Logesh has a question about CAP case from April. It's still pending, and online in the case status it just says case received. Is that normal? I would say we're still seeing that in about 10% of our petitions that we filed this past April. So it's not necessarily normal, but it's not uncommon. They're just, certain cases are slower this year than others. And if it's pending with the California Service Center, it's still not possible to submit a service request. If it's pending in the Vermont Service Center, you can, or your employer or their attorney can submit an e-request or a service request for outside normal processing time.
Emily, I have this tough question for you. It says my channel, the person is asking the question. He moved from client A to client B. He submitted the amendment with client B. The amendment approval came for a shorter period of time than that of the original H-1B approval. Can he go back to the old client A and work at that location because his I-94 is there?
Yeah, there's no guidance out there on this as far as I'm aware. I consider this to be similar to an idea of a dormant H-1B petition, which is in an old letter from INS that was sent to a guidance letter a long time ago about what happens when you transfer to another employer and your first employer's petition is still valid. Can you ever go back to that first employer during the validity of that petition? And this letter from INS says, yes, you can do that. It's called a dormant petition as long as that petition has not been withdrawn and has not expired. I consider this to be a similar situation where you have a valid approval to work at location A and another approval to work at location B. When B ends, you should be able to go back to A as long as the terms and conditions of that petition approval remain valid. Now, you also have a competing concept of the last action rule, which says that the last I-94 issued is the one that controls, and you can't resurrect the old one because the other one came out after. So and as far as I know, there's no answer to this question. The only way we'll get an answer is, if you go back to that approval and then later file your extension, and we'll have to see what USCIS says about it. I don't think we've had an issue in the cases that we've dealt with so far, but it is kind of a gray area, a very gray area.
Neha has this question, Emily. I think so you need to answer this one. She's asking, have you received any RFEs after September 11? The reason why she's asking is that the memo that went into effect, which says that they may deny without issuing an RFE. I want you to answer, have you received any RFEs after September 11?
Oh, yes.
Every day. Have you received any denials without RFE since September 11?
No. Yeah, we've really seen zero impact from that memo.
I want to tell you, Neha, that even though the USCIS has indicated they would deny the application without the RFE, those things what they are speaking is for those applications which don't include the basic necessary documents. Mostly it's not going to be applicable for most of the business immigration cases, especially if you're filing with the LCA, educational documents, I-94 passport. I don't think so we're going to get any denials without RFE. Now, if you don't file any LCA, you don't include any educational documents, and you just file an application, yes, there is a chance of denial without an RFE. But we haven't received anything. We haven't even heard anything in the business immigration as of yet.
All right, here's the question of the day. How safe is day one CPT? Are there any challenges that you can face?
It's as safe as jumping from 100 floors building, I would say. It is definitely not safe for day one CPT. People ask, can I do CPT for a doctorate degree after a complete master's degree? No, day one CPTs are not safe at all. Here is a couple of multiple reasons, is that these universities are not conducting classes. We know them. There are only like 3-4 universities, or maybe 5-6 universities out of the 3,000 universities and educational institutions that are there in USA that are granting these day one CPTs. You can ask this question, why not the 2,996 other educational institutions are not issuing the day one CPTs? Because the 2,996 universities are not considering day one CPTs as legal. Only these 4 to 6 universities are issuing. We have seen a lot of universities like Silicon Valley that got into trouble, Tri-Valley University that got into trouble. We have also seen a university called University of Northern New Jersey, which was actually a sting operation done by the immigration that trapped 3,000 students in there. So I want you guys to be very careful with these universities that are issuing the day one CPT. No, day one CPT is not at all safe. Now, if you cross the February 6th deadline, which is going to be 180 days, you might be in great trouble if you already have a CPT, because as Emily has pointed out, the August 9th memo kicks in. Previous to August 9th, it was the day your status gets denied, you've been counted toward the unlawful status. But now, according to Emily, from the August 9th memo, it is the day you violated the legal status, you will be counting the unlawful status. Why is the unlawful status very important for you is that if you collect 180 days of unlawful status, you have a 3-year bar. If you collect 365 days, then you have a 10-year bar in coming back into the United States. So day one CPT is suicidal. We do not recommend to anybody.
Venu has a question about I-140 where the employer is not sharing the receipt number. Is there any way to get that as an employee? Yes, you can file a Freedom of Information Act or FOIA request with USCIS and receive a copy of the I-140 filing that should have the receipt number stamped on it.
It's fairly easy to do the FOIA in USCIS, Freedom of Information Act. You can do it online. I don't think so you need a law firm to do it too. A lot of people I've noticed they're doing by themselves. I don't think so. You can mess anything in there in that online application. There is no filing fees. They do say that they might charge you some money for copying and all those things. I've never seen them charging any money too. So it's fairly simple and easy. It's taking about 30 to 60 days to get the information from online. Any updates on HR 392? Yeah, that's a tough question. Right now, the House has flipped to the Democrats, but as far as the HR 392 is concerned, there is no Democrats and Republicans. Both people are on board to support the 392, both Democrats and Republicans. The issue of the 392 is not 392 by itself. For the people to know what HR 392 is, that it removes the per country quota limit for the green cards. So the waiting period will come down to approximately 3 years instead of having all the way to 9 to 10 years right now. And going forward for those people, you're never going to get the green card if you could apply right now, unless you live for 150 years. So the 392 removes the per country quota limit. That will bring the priority date to approximately 2015 to 2016, and the next year it's going to be approximately 2017 or 2018. So there will be a waiting period of 1 to 1.5 years for the Indian nationals and Chinese nationals when they remove the per country quota. But it's not about Democrats and Republicans, it's the House and the administration. They are not acting, they are not passing any bill. No major immigration bill has ever been passed in the past 35 years. There was some minor IRA immigration law passed in 1997. That's just a minor bill. When our office started in 1997, April 1st, was the IRA initiation. That's the law that was passed. And the previous bill to that one, which was the major legislation, was passed in 1985 in the Reagan time. Most of you guys might not have been born there. So if it's not the Democrats and Republicans, nobody wants to pass these things, because if they put that one, everybody wants to attach their things and they get into fight, then never pass any major immigration legislation. But it has both parties supporting it.
All right, Abdur has a question. He's on F1 and he's already graduated. Now he's got the initial 12-month OPT. He's planning on traveling, but his visa stamp expired. So
Yikes.
What kind of issues will he come across when he's applying for the visa stamp at the consulate? I think that's a tricky situation to be in, going for F1 visa stamping after you've already graduated and are using your OPT. The reason for that is the purpose of the F1 visa is to allow you to come into the United States to study. At this point, you've already completed your studies and are now working. So you may find it difficult for a consular officer to issue you the F1 visa to study when your intention is to work. On top of that, F1 visa requires non-immigrant intent. So you're going to have to prove to the officer that you intend to leave the U.S. when your program ends or when your OPT ends. Which may be difficult to do when your job is here in the U.S. Now you can't show that you have a job to come home to in your home country. You may not have a residence in your home country anymore if you've been in the U.S. for several years. So you may not have sufficient ties to your home country to be eligible for that visa stamp.
How long it's going to take for the H-4 EAD? That's a question from YouTube. H-4 EAD is taking approximately 100 days if it's been filed alone. But if it's been filed along with the change of status from F1 to H1, it's taking approximately around 8 months, because H4 is taking that much time. They can't adjudicate the H4. If it's been filed along with the H-1B, they normally will adjudicate H-1B and H4 and EAD at the same time.
Vamsi has a question, came up on my blog today as well. Can you port an EB2 priority date to EB1? And the answer is yes, you can. When you're filing your EB1 I-140, you should submit a copy of your EB2 I-140 approval, or even EB3, and request that they port the date from your current approval notice to the new approval notice. The regulation applies to EB1, EB2, and EB3, and says that if you have multiple I-140 approvals, you should be accorded the earliest priority date.
One other couple of clarifications I want to give about EB1. A lot of people are under the impression that if you are if you're a higher level executive manager, you should be able to file an EB1. That is not true unless you have worked at a higher level position for the same subsidiary company or for the same sister company outside this country at a higher level for at least 1 year preceding to coming into United States within the 3 years, you must have worked for that company. Just because you're working, let's say you're working with company A here at a higher level executive, that by itself is not enough to file an EB-1. You need to have work for the A's subsidiary company or a sister company back in foreign country at a higher level position, and you might have been transferred. Then only you can file in EB-1. There are some exceptions available. If you are, Oscar Award or Nobel Prize, you can obviously get EB-1. It's not that tough if you get an Oscar or Nobel Prize. If not, if you even get the nomination, you definitely have a higher chance. But if you are not one of those extraordinary persons, it's not that easy to file in the extraordinary capacity. A lot of people ask that I'm at a higher level, I wrote this article. Those by itself mostly are not enough unless there is some extraordinary thing that is there. Let's say, for example, you are the WhatsApp founder, or maybe the Facebook founder. Yeah, definitely you will come into the extraordinary ability. Any other description? I get a lot of these questions on EB-1, Emily, every day in the conference calls and in these things.
Yeah, I mean, I think that when you read through the criteria, right, so if you go to the USCIS website and look up EB-1, it gives you a list of 10 ways that you can qualify for the EB-1 category, and you have to prove you meet 3. That's just the beginning of the story. Once you prove that you meet 3 of those criteria, you still have to prove that in the totality of the circumstances, you're the cream of the crop in your specific field. So it's not enough just to meet 3 or 4 or 5 or 10 of those criteria. It's a kind of a 2-step process of how USCIS looks at it. So it is a pretty high bar.
Prasanna has this question: anything expected in EB-2 changes in 2019 for the priority dates? If you're expecting that the priority date to move beyond May of 2010, because May of 2010 is when it was current in 2012, no, we are not expecting that to move beyond May of 2010. We do expect some movement though, but I'll be very surprised if it crosses May of 2010 in EB-2 category.
Yeah, I kind of feel like that's the whole purpose of that dates for filing chart. When it comes out in October, that's kind of their prediction of where the dates will be in 12 months. Yeah. So by the end of the fiscal year, we might be at those dates that are at the filing chart, but last year they never made it that far.
Yeah.
Alan has a great question. So the 240-day rule for H-1B extensions, this is the rule that says that when you're filing an extension with the same employer, while the extension is pending, you can continue working even for 240 days beyond the date your I-94 expires, as long as your extension is pending. His question is, does that also apply to his wife's H-4 EAD? And that answer is no. If the EAD expires and her new EAD is not in her hand, she has to stop working. The EAD rules are different from H-1B rules. It's a completely separate legal document, so it does not have that same protection that allows someone to work while it's pending.
Anything we have not covered, Emily? Got like 256 questions in the
I think one last
YouTube.
question. Any changes to the TN visa with the new NAFTA?
New NAFTA.
I don't even know what it's called anymore. I keep forgetting.
Yeah.
Not really. Very little changes to anything related to TN visas at this point based on the new agreement. All right, so I know we have a lot of questions I'm trying to scroll through that we didn't get to, but our time is about up. So we apologize that we're not able to get to everybody. Please join us again on Tuesday. We'll be here again on either Facebook or YouTube. And again, if you have questions, you can always join our daily conference call. Go to rnlawgroup.com. There's a button to click conference call, and you'll find the daily schedule for that, as well as the dial-in information. If you want to set up a consultation, you can do the same thing by going to rnlawgroup.com. There you'll be able to view all of our attorneys, find out who's got the best experience in each practice area, and decide which you want to go with, and schedule your appointment conveniently online. And feel free to subscribe to our Facebook page, RN Law Group. If you subscribe, that way you'll be notified when our Facebook Lives come up. You can follow me on Twitter at Immigration Girl, or you can subscribe to my blog at immigrationgirl.com as well.
Thank you guys for tuning in. Thank you so much.